Hi, everyone. Welcome. I'm Lindy Laurence. We are glad to be here today, hosted by ORPIB. They are a wonderful community partner to Rational Unicorn, and we love any opportunity to connect with your community, our community together. So today we're going to be talking about understanding business relationships with workers. A lot of folks we've been doing this for 3 weeks in a row now. The first week we talked about business fundamentals. Last week we talked about contracts. I nerded out a little bit. Everyone knows that I really love contracts. This week, we're going to be talking about understanding business relationships with workers. And if you've joined us for the other two previous weeks, those were good foundational and background information about this. And if you're just joining us today for the first time, please let us know if you have any questions or anything that you'd like to chat about, and we'll just go ahead and go through this. Just a disclaimer, this is general information provided to help empower and inform you. This is not specific legal advice for you and your situation. Legal advice is when you sit down and you say, hey, I'm going through this situation. What do you think I should do? And I can say, well, based on those facts and circumstances, we think this is the recommended path forward. This is just information. If you want to chat with me about your particular legal situation or questions that you have, you're welcome to bring up questions here. If you want to chat about things more in depth, I recommend reaching out. We'd be happy to schedule a consultation with you. My name is Lindy Laurence. I'm the owner and managing attorney at Rational Unicorn Legal Services. We're a small law firm that was founded in Portland. We now serve the whole West Coast. We have 6 attorneys on our team that are ready to serve you. And really, the thing to keep in mind about the firm is that we're a little bit different. If you can't tell by the name itself, we're very different from a traditional law practice. We are humans first. We are attorneys. We are very good attorneys. We provide great service, but we do it in a very human-centered way that centers you as a human and as a person inside that legal advice. We offer free 30-minute consultations. So if you ever want to just reach out and chat with us about something, we're always happy to connect with new folks. And we are a certified benefit company. That means we follow the triple bottom line of putting people first, and then the planet, and then profits in that order. So today, our roadmap is going to include an overview of worker classifications, differentiating between independent contractors and employees, the legal requirements for hiring workers, best practices for engaging with independent contractors, and also with hiring employees. We will have opportunity for Q&A at the end, but I'm going to ask if you have questions, could you just raise them as they come up? Because I think that often questions asked in the context of the material we're covering at the time are easier to answer. So let's get into it. We're going to talk about, first of all, worker relationships. The way that you classify your workers, whether they are as an independent contractor or an employee, is pivotal for you and your business. This is a foundational classification that you really have to get it right. The consequences for getting it wrong can be almost existential and can be very serious. So we want to make sure that everything is classified right because it will impact how you manage payroll and taxes. It will affect eligibility for things like health insurance and retirement plans. It will influence the legal responsibilities you have as an employer, as well as implicate compliance with labor laws. And we want to make sure that we properly report anything to government agencies. Um, when there are multiple impacts on taxes, benefits, and legal responsibilities, just compare and contrast between an independent contractor and an employee. Employees, employers have to withhold income taxes. Probably everyone in this room is self-employed or actually, raise your hand if you're self-employed, if you're running your own business. I know Elizabeth is, I know Chaz is, I don't know about Mary Elizabeth or Bunny, but my guess is Mia, yep. Okay. So we're all very familiar with self-employment tax, right? That 15.3% that we pay on our income to the federal government every year. When you have employees, you're splitting that self-employment tax. So your business is paying half of it, 7 point something something percent, half of 15.3, and your employees are paying the other percent. So if you have employees, you're obligated to withhold those taxes for Social Security and Medicare. Also, That's very different for independent contractors. Independent contractors are responsible for their own tax payments. Employees can receive company provided benefits. Contractors do not. Um, Accurate classification is going to, we have so many horror stories about this. Accurate classification is just going to help you avoid some headaches down the road. So, what are the criteria for classifying workers? When you're thinking about, I need to hire someone, um, how do I determine whether this person is an independent contractor, a full-time employee, a salaried employee, a part-time employee? How do we make those decisions? When you're thinking about the worker themselves, the things you need to keep in mind are the control criteria. Let me zoom out 1 second. The IRS has like a 17-part common law test of like 17 different questions you can tick through and ask. Every single state has a similar test that they go through to determine, is this an employee or is this an independent contractor? And fundamentally, what they're looking at is the degree of control that you have over the worker's performance of those duties. So control criteria is very pivotal in this consideration, in the evaluation. We're looking for the degree of control that you have over the worker's tasks and your schedule, and how much instruction and training you're providing from your business. We're also looking at the nature of the relationship. So, for example, if you have contracts that say they're an independent contractor, but everything else points to them being an employee, those contracts will not do a lot to protect you. If you have a very permanent relationship with your worker and they provide you services on an ongoing basis, that tends to indicate more of an employer type relationship. The other criteria are also financial criteria, how the worker is paid, if it's hourly, salary per project, whether or not you're reimbursing for expenses or investment in tools and equipment. And finally, when we get down to it, the IRS common law rules is really looking at behavioral. Does the company have the right to control what the worker does and how you do the job? Do you have the means to control, do you have the right to control the means and the manner of the work that they're performing? Are there business aspects of their job that are controlled by you as the employer or the payer? And are there written contracts or employee type benefits? My very first job out of college was back in the late 90s. I was working for Cranium, the startup game company, and we had this was a really, really sensitive topic for the company. Uh, I'll go to this slide and I'll keep telling you the story. So we had a whole bunch of employees. We had probably 24 employees, and then we had some independent contractors that were helping out on graphics and things like that for the game cards. And the company was providing the office space for the contractors. The company was buying the computers for the contractors. The company was giving the independent contractors the same kind of benefits, like when we did Friday lunches or when we were like giving everyone swag or branded gear from the company. The contractor was really folded into the family, so to speak. If you looked at them from the outside, you would not know that the contractor was any different from the employees because they were treated exactly the same. They were on the same footing. They maintained the same type of schedules. Now, if anyone here is old enough to remember way back in the 90s when Microsoft got dinged over this, Microsoft actually went through a really big deal where they had misclassified a number of their workers, and this was it was top of mind for everyone at the time because the risks of worker misclassification are catastrophic. There are penalties, there are back taxes, there are lawsuits and legal disputes, there's reputational damage. You may have to provide retroactive benefits. And so I I now we are seeing this more in the context of like gig work and side hustles. Is your Door Dasher, are they a contractor or are they an employee of DoorDash? Your Uber drivers, are they employees or are they actually contractors? And as we look at those tensions or those disputes, we can begin to see the public policy that underlies this and why there's this strong public pressure to classify workers as employees instead of independent contractors. We can see it in the California ABC test. That may not apply here in Washington and Oregon, but as lawyers, we know that where California goes, it is very typical that the whole country eventually follows. And so we watch these types of things in states like California very closely to understand how are they treating workers, what are the considerations and the evaluations that they go through for identifying whether a worker is an independent contractor or an employee. This is an enormously complex area of law, only because there's quite a patchwork of things that implicate it. We have state law where your business is located. We have the state law where your worker is located. We have state employment laws as well as state tax laws. And then we have federal employment laws as well as federal tax laws. And so this is one of those areas of law where there's just a number of different overlapping considerations, and any conversation about this really has to take into account your facts and circumstances, what your business is doing, the characteristics of that worker, what role they're playing, the length of time, and that sort of thing. So my caution to you is don't take these things for granted. Do not approach this sort of like as a one size fits all. Oh, if I have an independent contractor agreement, I can just put that in place and it just turns anyone into an independent contractor. The state will get involved with this, but they very rarely get involved unless somebody asks them for their involvement. It's usually some disgruntled worker that maybe is separated from maybe you decide, hey, we're not going to keep using you anymore. Things aren't working out. And they go and they file unemployment. And you say, no, you're not eligible for unemployment. You weren't an employee, you were an independent contractor. So they raise a ruckus with the state and they say, I was misclassified. I should have been given overtime pay. I should have been given benefits. They should have paid half of my employment taxes. That's when the state gets involved. And if you get a letter from Bali in Oregon or from Washington Department of L&I, or if you have contractors in another state and maybe they're filing down in California, you're going to get a letter from the Employment Security Office, whatever that office is in the state, saying, we're opening an investigation and we need you to respond to all of these things. And that's not a great letter to get. It's scary as an employer to be reading that and to wonder, oh, shoot, how's this? Like, I don't know how this is going to shake out. I don't know what's going to happen. Depending on that specific worker, maybe it's something that you're able to defeat, or maybe it's something that you're not able to overcome and you get stuck paying these back taxes and fines. So I'm not trying to scare anyone. That is never my goal as an attorney. My goal is to merely light the path ahead of you so that you can see there are some big potholes here. I should tread carefully. And if you have questions about these things, I really encourage you, reach out to me or another trusted advisor who can offer you good recommendations and good counsel on this. All right, we're going to talk about independent contractors. Independent contractors, we're very familiar with this concept. We often, I know many of you often have independent contractor relationships with your clients. Maybe you provide professional consulting services, maybe you provide mediation or marketing or graphic design. We provide legal services. We are independent contractors. When we work with clients, we operate independently without direct supervision. So our work is self-directed. We own our own tools and equipment. We're using that to complete our work. We set our own hours, and unless clients are like, hey, I'm only available to meet at this time. I mean, my clients don't have a lot of control over my schedule, and I would guess that your clients also don't have a lot of control over your schedule. You sort of set your hours and say, I'm available from here to here. That's my vacation. That's my annual, yoga retreat, whatever it is you do, you set your schedule and you expect folks to line up with it. And often, but not always. Often, independent contractors will have multiple clients at the same time. So maybe your client takes up a large amount of your capacity, and you maybe have two or three clients, or maybe you're fully focused on one project for a limited time. But generally, you're holding yourself out to the public as a professional who engages in this kind of work, and you're always looking for the next client to work with. Those are characteristics that we think about when we're thinking about independent contractors. Independent contractors have a lot of advantages. One of the things that we used to talk about at Cranium is like that was a great way to what we would call rent talent, right? You need an expert to come in for one project or to provide insight or direction on a certain thing. And you really just go out and you rent an expert. You don't have to onboard them. You don't have to do all of the things like the training you would with an employee. You just say, you're an expert in this field. We need you to come and do this. There's cost savings. You don't have to add them to your health insurance. You don't have to add them to your retirement plan. Enormous flexibility. You can scale your workforce up or down based on the project needs. All you have to do is give them the 30 days to cancel the contract, or when the project's done, the contract is finished. And it gives you access to specialized skills. Again, that idea of getting access to the experts with specific skills for those project terms. In most cases, that independent contractor will work in their own space with their own equipment. So you don't have to worry about grabbing a new laptop or putting together a new email address or giving folks access to your systems or all of those things. Your contractor, your independent contractor should already have those things in place, which means that onboarding is a lot faster. And the nice thing about independent contractors is you can very quickly add diverse perspectives and different viewpoints by adding new people to your team. Best practices? Well, if you've been here for the last two things, you know that my number one thing I'm going to say is you should probably have a contract for that. If you have a relationship with someone where there is more than $500 that's being exchanged between you and the work will go on for at least some period of time, contracts are the way to go. Make sure that everyone is literally on the same page. They can outline the scope of work, identify your payment terms, and talk about the term of or the length of the engagement. When you report income, you're going to have to use Form 1099 NEC. The NEC stands for non-employee income. And if you pay anyone more than $600 a year, then you will have to file that form. Um, your accountant or bookkeeper can help you with that, but there's also tons of websites online like Tax 1099 or things like that that will let you do your 1099s, and it's like $1 or $5 a piece. So if you have a number of these that you need to send out, do so. One of the things you should do is when you're working with contractors and you're going to pay them more than $600, ask them to share a W-9 with you. The W-9 is the taxpayer identification form. It lists their name and the name of their business, their tax ID, so you know everything to properly report on that 1099, and their address and contact information. So you have everything you need from that W-9 to complete your 1099, except for the total amount of the money that you paid them in that year. You don't have to make any tax withholdings for your contractors. And I actually recommend that in your independent contractor agreement, you include a tax indemnification. The idea is the contractor is supposed to pay the taxes on that income, not you as the business owner. And so having that tax indemnification just acts as one additional layer of protection for if the state ever does come back, you can go back to your contract and say, no, my contractor paid these things. So even if I am liable for them, my contractor has already agreed to indemnify me for that. So again, it's just if the worst thing happens and you get a call from the state and they need to investigate these things, your contracts are going to provide you at least some of the support you need to help navigate the project. And keep good records. These days, when everything's electronic, I just recommend that if there's like an important email that you print it out and stick it in a folder, if there's an important conversation that's happening over text, screenshot it, have some discipline so that your communications are at least in the same place so that if you need to research things or pull records together, you only have one place, not like a bunch of different places. You don't want to be looking on Slack and on your phone text and in your Gmail. It's hard. when when you're scanning a bunch of different places. Okay, employees. So compared to an independent contractor, employee characteristics are very different. Instead of a temporary or short-term relationship, we're looking for something that is ongoing. This is really, you might rent expertise, but employee characteristics, you're really looking to hire skills. You're really looking to hire talent, the folks that you want to be on your team, rowing next to you, headed in the same direction. So employees typically have a long-term continuous relationship, and the company, you as the employer, have significant control over their tasks, over their schedule, and how they work. Um, they usually work fixed hours that are determined by you. If they're a remote employee, maybe your organization has like core hours that you require everyone to work. So, like between the hours of 10 and 2, so that we can always coordinate meetings easily. Or we're always here Tuesday, Wednesday, Thursday. If people are out of the office, it's on Monday or Friday. Whatever you need to do to make sure that your employees have the right connections to the team. Employees also often use the tools and equipment that are provided by the company, right? You get them a computer or a laptop, you're providing them with a cell phone or paying for their cell phone service, whatever it is that they need to do their job, you are the one that generally has to provide that. And if there are any benefits, either voluntary benefits that your company provides to employees or mandatory benefits that the federal or state government require that you provide them, employees are eligible for them. They may get things like unpaid sick leave or paid time off under the Oregon Paid Leave Act, or maybe they get federal holidays paid, where you wouldn't, like, if your office was closed for a federal holiday, you wouldn't pay your contractor for that day, but you would pay your employees for the 4th of July or Memorial Day. Employers also generally invest in the training and professional development of their employees. So this is one of those, again, you are investing in them for the long term. You want these folks on your team for a long time, so you want them to be highly skilled and very adept at what they do. And probably the biggest reason that we see this push to characterize folks as employees instead of independent contractors is there are so many legal protections that are available to our workers who are employees that are simply not available to independent contractors. And so we can see the strong public policy of wanting to protect people, wanting to ensure that human beings have access to paid time off or sick leave if they need it, or holidays or regular schedules, the sorts of things that we as humans recognize we all need those things to be able to live thriving, fulfilling, satisfying lives. So, the advantages of hiring employees, well, you get a lot of team cohesion. It's uh, we have an employee right now. Her name is Rupal. She just had a baby a couple months ago, and it's our first baby unicorn. We're so excited. She's just the most adorable little thing. And Rupal is out on leave right now, and so we have an amazing person named Vera who's filling in while Rupal is gone. And it's so different because we've got Rupal. Rupal's our employee. We know Rupal. We love her. We miss her. And now we have this fabulous like substitute Rupal, Vera, who's also amazing. And you get to know your contractors. They become part of your team, but eventually they are going to go. And so when we hire employees, we're looking to develop those long-term, deep relationships with folks who are going to be around for some time. Um, Again, we're looking for a long-term investment into their skills. We want to make sure that once we've made that investment, that folks stay around. So we're looking for ways to retain our employees, create company loyalty, give them a satisfying and meaningful work to do. Employees also can be incredible brand ambassadors and almost like organic marketers for your company, because they will, like, when folks hate their jobs, they'll tell people, but also when folks love their jobs, they'll tell people. And so your company, that helps build your reputation as being a great business to work for. Or, oh, I've heard you treat your employees really well. So and so is telling me how much she loves working for you. Those are great things for, just sort of word of mouth goodwill for your business to reap from the community as a result of having happy, enthusiastic employees. Also, If you have an employee and your business has a new need, you can pivot. You can say, hey, are you interested in taking on this new task or learning this new skill because this thing happened? We see this all the time when technology develops. There's generally going to be somebody who's like super enthusiastic about it in the office. And you're like, really? You want to learn this thing? You want to kind of become the go-to person? Okay, great. You're on it. And that can be a great way of developing competencies in your team as well as expertise in your company. Employees also provide a lot of consistency as well as help shape and maintain the company culture. Not only are they brand ambassadors, but employees can be great ambassadors to your values and your mission as well. There are a lot of federal protections for employees. The first one that I want to talk about is the Fair Labor Standards Act. So FLSA ensures minimum wage, overtime pay, as well as make sure that we have child labor protections. President Biden made a number of changes to the FLSA this year, as well as changes that will begin January 1st, 2025. And I want everyone to pay attention to this. If you have an employee that is classified as non-exempt under the FLSA, that means they are not eligible for overtime pay, which means that you have to pay them a minimum salary. In years past, the FLSA minimum salary was not updated to match inflation, and so it stagnated around $28,000 a year. So long as you paid your worker, your employee more than $28,000 a year, more than that minimum salary threshold, you could get away with treating them as exempt from overtime pay, even though they were not even making $30,000 a year. Now, with the new changes effective January 1st, 2025, you must pay your non-exempt employees at least 56,000, I'm sorry, $58,656. That is the minimum salary that you must pay your employees. So if you have an employee now and they're on salary, come January 1st, you're either going to have to adjust them to be hourly or bump up that salary so that you meet that minimum salary threshold. And you don't have to remember this right now. You can come to another Rational Unicorn seminar. We'll be having some towards the end of the year where we remind you about all these things. But just plant a flag in your mind. There are wage changes that are coming. There are also federal anti-discrimination laws. We are all very aware of these, right? You cannot discriminate on people based on their personal characteristics like race, color, religion, sex, national origin, age, disability, genetic information. Those are the federal protections. Oregon has additional protections that add some more onto that. So the bottom line is you should treat people with respect and dignity. Don't discriminate against people for any reason, but especially for these protected classes. The federal government also put into place Family Medical Leave Act. That provides employees with up to 12 weeks of unpaid but job protected leave. But that only applies to you at a federal level once you hit 50 employees. So for many of our clients and probably for everyone in this room today, we may never hit that. Like I can't imagine Rational Unicorn having 50 or more employees. We would be enormous. Like that, I can't I'm sure some of you are also like, wow, I just don't know how I'd even manage a business that big. If you have more than 50 employees, FMLA automatically triggers and you have to give them at least 12 weeks of protected job leave, which means they can go take care of their family and come back and they're guaranteed to have that same job or an equivalent position. We also have the Occupational Safety and Health Act, which says, hey, you've got to make sure that folks are in a safe environment. They're not exposed to chemical hazards. If they do have any hazards, folks have the appropriate protective gear and equipment, whether that's masks, whether it's eye protection, wrist guards, rebreathers, things like that. The Equal Pay Act. Every woman in the room is going to laugh at this because we just know that even though this is a law, people don't follow it. But it mandates that you have to pay women people equal pay regardless of gender. Now, for every woman who's making 76 cents on every man's dollar, we know that this is not really a reality yet. But we as small business owners can make this a reality by ensuring that everyone that we work for receives the same salary regardless of their gender. Then this is another one that maybe probably won't apply to many people, but it's the WARN Act, where if your company is going through layoffs or going to be closing like a plant or a manufacturing facility or a location, you have to provide at least 60 days so that your workers have plenty of time to accommodate for that change. And there's also retaliation and whistleblower protection so that if employees make complaints or they file a report that you're not complying with these things, they are protected from retaliation in those disclosures. We also have a lot of organ protections for employees. So again, like there's the federal layer, you got to comply with that. And then the state layer comes in. The state layer is often much more protective. So we can see that the Oregon minimum wage is 14.20 an hour as of July 1st. Now that's a pretty good minimum wage. It's not the highest in the nation. The highest minimum wage in the nation is in Tukwila, Washington, actually, just a few miles from where I live. And that wage is set at almost $20 an hour. But Oregon has a very healthy minimum wage that is almost twice the national minimum wage. And so you can see you have your federal protections and then you have your state protections that may be more robust. State protections cannot be more lenient than federal protections, but they can be more robust. And we see that, especially in our progressive states like Washington, Oregon, and California, that are very focused on protecting the rights of workers and ensuring that employees have the protections they deserve. So in Oregon, employee benefits include minimum wage of 14.20 an hour. You must pay folks time and a half for hours worked over 40 in a week. You have to give them standard rest and meal breaks. Oregon employees are also eligible for sick leave, maybe paid, maybe unpaid, depending on the number of employees that the business has and depending on where it's located. So, Oregon has this sort of complicated rule of if you're in Portland, if you're within the Portland city limits and you have 5 employees, then you have to do this. If you're outside the Portland city limits, you can have 10 employees, but you have to do this. So, what I recommend is you visit the Oregon Bureau of Labor and Industries, that's the Bali website. I can put the link in the chat, or you can just Google Oregon Bureau of Labor and Industries or Oregon Bali, and it will pull up. The states are promoting compliance. Their number one goal is compliance, not enforcement. States like it when everyone just follows the rules. And so Oregon has done a very good job. Thank you, Janine, for putting that in the chat. Oregon has done a very good job of putting plain language resources out there so that you can click on the link and say, I'm an employee. What should I know about my rights? I'm an employer. What should I know about my responsibilities and duties? And you can read through that and see and knowing your facts and circumstances, you can match yourself to it. Oregon also has a new Oregon Family Leave Act. This is amazing. I love seeing laws like this. You can see the Federal Family Leave Act, it's also 12 weeks, but it's unpaid. Oregon, Washington too, has a new Paid Family Leave Act, which offers 12 weeks of paid leave for family and medical reasons. This is this is a program that is funded through payroll taxes, and the benefits are paid through the state. Your business does not need to do anything other than say, "Congratulations, you're having a baby. We will see you in 12 weeks." It was a very easy process. We just went through it with Rupal. I can tell you the forms were straightforward. It was easy to log in the websites and provide the approvals. Oregon did a very nice job of helping us understand what do we need to do and when do we do it. And Oregon also provides a stipend or a grant to small businesses that will help you cover the cost of your employee being out. So if you're a small business owner and you have to pay for somebody to come in and fill in the role while your employee is out on leave, you can get up to, I think it's $3,000 to help cover those expenses. And so again, Oregon is just trying really hard to make it easy for families to take care of one another and for businesses to take care of things while their workers are gone, providing for those important family duties. So I really love this. I love laws that promote human dignity and human compassion and allow us the opportunity to take care of our loved ones, whether it's something great like celebrating the birth of a new person, or maybe you're caring for an elderly loved one or somebody that is sick and you need the time to be with them. Either way, it's really important that our workers have the opportunity to do that, as well as have the worker protections and the financial support as well. Legal requirements for employees. So we've got the wage and hour laws. We want to make sure that you are complying with minimum wage, overtime pay, and record keeping requirements. So that's important. You will have to withhold taxes from for your employees, and you'll do that on a W-2. You have to withhold federal income tax and then half of those employment taxes like Social Security and Medicare. We recommend working with a payroll service provider. At the firm, we use Gusto. We recommend it for a lot of our clients. When I ask clients, who are you using for your payroll? And they tell me when they say Gusto, they're always smiling. I will be honest with you, we hear horror stories about Paychex, ADP, Wells Fargo. It's just things like they withheld the taxes, but they didn't pay them to Oregon for us. So now we have a lien against our business and we can't get Paychex to respond. So there are some really disreputable companies out there. I strongly encourage you to maybe shop around a little. Try Gusto. It's very affordable. One of the things that I love about Gusto is you, as a small business owner, can get everything set up, but they won't charge you until you turn it on and begin running payroll. So that allows you to like get all the data in the system and not worry about, oh, they're going to be charging me for it even before I need it. So Gusto's great. We don't get paid anything. I just like to share good resources when we have them. So Gusto's great. You may also have to provide mandatory benefits like health insurance or retirement plans and paid leave where applicable. Then you also have to comply with labor laws. And I'm going to be very honest with you. Um, Employment hiring is super complex because if you have a remote employee, like for example, let's say your business is in Portland and you've hired somebody and they live in California, now you have to comply with California's labor laws, even though your company is in Oregon. The employment laws of where your employee is sitting, where do they have boots on the ground, where are they physically located while they're working for you, it's that law that will apply to you. So now imagine you're a small business owner, you're doing your things, you want to hire remote employees, and you've got one in California, now you've got one in Idaho, got one in New York, maybe you have an employee in Florida. Now you have 5 or 6 different states that you need to navigate, and not just state level things. You have to think, okay, where in New York are you? What is your zip code? Because now I need to see, is there a local minimum wage that's different from the New York State minimum wage? So when you're thinking about this, it becomes an each new person adds a layer of complexity. So we'll get there. I'm getting ahead of myself. Best practices for hiring employees. Make sure that you clearly define job roles and responsibilities. If you are posting jobs anywhere, make sure that they comply with the requirements for job postings. In Washington, there's now a law that any job posting must include a salary range. It is the law. And what we see is these like litigation mills. We see like kind of sketchy law firms coming in and filing class action lawsuits against companies for a failure to do something like failure to post the job salary range. And that is a real thing. Um, I have not seen these lawsuits become fruitful, but nevertheless, if you are served with a class action lawsuit because you failed to put the salary range on your job description, that's a rookie mistake. Don't do it. Do not don't give these bad legal actors, these folks who are like using legal processes I mean, they're kind of using it in convoluted ways. That's not the idea. The idea is for um, for businesses to comply with salary posting requirements. And if you don't, you can hold them accountable. But the idea is not that we do class action lawsuits. The idea is that workers have the knowledge that they need to know, is it even going to be worth it if I apply? Is that a salary range that will be acceptable to me? So make sure you comply with all those things. I recommend structured interviews to assess candidates, like actually have an interview process. Put folks, have a standard set of questions that you can compare and contrast folks' answers to. Think about background checks. Think about things like reference checks. I've never seen anyone give a like hand out a name for a reference of somebody that wasn't going to give them a glowing review. That's just most people are not going to give out the name for a reference and they're going to be like, "Oh my God, Lindy was terrible. Like, don't ever hire her. She was the worst." um, Most people are going to find somebody and give you a name that gives them a valuable reference. So I'm not sure if references are really that helpful in the hiring process, but background checks can be. And I'm not saying that things on a background check should disqualify folks. I love second chance employment, and I love it when employers do not make job applicants check the box, right? Do you have a felony conviction, or is there anything in your background we should know about? I love it when those things are left off. I think I strongly believe that people can change who they are and that one mistake should not define you for the rest of your life. But if you have a business where you're working with vulnerable people like children or doing work with students or disabled adults or the elderly, you should probably know if there is anything in that person's background. You may also work in an industry that requires it. For example, financial services may require a background check if your employee will have access to banking data or financial information. So there's lots of reasons to do it. Make sure that your hiring practices are fair and unbiased. This is probably the hardest thing because as humans, we just have implicit bias that's built into us. So be aware of what your bias is. Try to find ways of overcoming it or managing around it. It's I think we all understand the need and see the benefit of having different perspectives and different backgrounds and different viewpoints in our businesses. That all of those different perspectives help us do better business. And we recommend using an offer letter, right? I don't like employment agreements. Employment agreements can get really messy. They kind of smell like contracts, and we like the at-will nature of a job where if your business needs to quickly pivot and you need to separate from an employee, maybe things aren't working out, maybe you lost funding, maybe you won the lottery and you just don't want to work anymore. Whatever the reason is, your business deserves the opportunity to quickly pivot. And if you need to separate for an employee for any reason, the at-will nature of employment gives you the opportunity to do that. So I like to recommend that clients use an offer letter as well as a confidentiality agreement. If you're also working in an industry that or a company that develops a lot of intellectual property, maybe you're doing um, development work or curriculum development, or maybe you are creating inventions or putting together marketing campaigns, you may want to consider an inventions and assignment agreement that basically says anything that I create while I'm an employee, any inventions or intellectual property I develop during my employment belongs to my employer, which makes sense. If you're paying the person to use their brain to think about those innovative things, those innovations should be owned by you and your business. An offer letter clarifies the job, the hours, the ticky-tacky details, it outlines what benefits folks are eligible for, who they're going to report to, when their start date is. It just puts it all down in a nice format where folks can look at it and see what's actually being offered. A confidentiality agreement is great to put into place at the very beginning. We recommend that you have your employees sign all of these protective covenants right at the start because offering somebody employment in exchange for their signature is considered consideration to the contract. If you have them start their job and then a year later you're like, hey, I also want you to sign this contract, you must offer additional consideration for that contract to be enforceable. So you either have to offer them some sort of additional payment or maybe a raise or a promotion, whatever that is. So doing it all at the beginning not only standardizes your process to make sure everything's in place right from the start, but it also prevents you from having to navigate additional consideration for signing those contracts later on. Some of the protective covenants that we recommend are, well, non-compete agreements. We're going to talk about this. I'm doing a seminar on October 4th or October 8th about this, where we're going to talk about non-compete agreements and the very rapidly shifting landscape around non-competes. We, in Oregon, Washington, and California, non-competes for employees are disfavored. They are unenforceable unless you pay your employees a significant amount of money. That's in Washington and Oregon. In California, they're unenforceable, period. They're just void. Doesn't matter if you have someone sign them, they're completely unenforceable if they're an employee. In Oregon and Washington, you have to pay your employees a significant amount of money. It is inflation adjusted. It's over 108,000 in Oregon, over 120,000 in Washington. So the non-compete agreements are not enforceable against, your sandwich shop workers. Here's one of the reasons that this is going on. So there are a lot of franchises, such as places like Jersey Mike's or um, uh, Subway, right? Where they will have their employees sign a non-compete agreement. And we're talking about folks that are making sandwiches, right? It's not proprietary. I go up and I tell you what I want on it. You're not using any creativity. You're just putting things on the bread. And what they do is they're having their employees sign these non-compete agreements, and then this hourly employee who makes sandwiches cannot walk down the street and go work for Jersey Mike's because they were just working for Subway and they can't do that, right? That's competitive to them. So we're seeing these non-compete agreements preventing people from having gainful employment in industries where it really is not merited. And I think objectively, we can all look at that and say, yeah, like fast food workers, that's silly. They're not doing anything that's very competitive, especially if they're just like, do you want fries with that? They should not be restrained from getting meaningful family sustaining wages from a job that, really doesn't have a whole lot of competition involved in it. But your business may be different. You may have highly confidential information. You may have strategies and business goals and objectives that you are going to pursue, and you don't want your employee getting your good ideas, leaving your company, and then using those ideas against you competitively. So there are other ways that we can put together protective covenants that protect you from unfair competition between you and your employees. And I won't go into that in great detail because holy cow, I need to wrap this up. But we will have a seminar on October 8th to talk about that. We recommend employee handbooks and policies simply because if it's written down, it's easier for people to understand. They don't need to come to you and say, hey, what's our policy on vacation? Or remind me again, how do I do an expense report? And what kind of accommodations can you make for me? I think I need a reasonable accommodation due to this. Or what are our holidays? What's our paid time off? Write it down, give it to employees so that they can understand and regularly update it so that it reflects current laws and your company practice, and ensure all employees have a copy of it. It's just a wonderful way to both promote and weave your values into your company culture, and also it's getting everyone onto the same page. We like alignment. Um, Remote employees. Okay, so I kind of touched on this. Location matters. Location matters most of all. Location is the very first thing you should be thinking about with employees is, great, so where do you live? And where will you be working? Great, your house is in Washington. Tell me which county, tell me which city, because Washington is one of those janky places that has different local minimum wages. So whether your employees in Seattle, SeaTac, Tukwila, all these different places, you know, you'll want to be able to navigate that. Same with Oregon. Oregon may have different minimum wages based on the location of where the employee is. And if they're anywhere outside the West Coast, we definitely want to look at it. Now, here's a tip. Or California is the most difficult state to hire employees in. It has the most compliance burdens. It has the most difficult agencies to work with. They have the most restrictive and or protective laws for employees, depending on which perspective you're looking at. So unless that person is absolutely amazing and you can't find that person anywhere else, maybe consider not hiring an employee in California. Just do yourself a favor and see if you can find an employee locally or find one without those things. But if you can figure out how to navigate California employment law, you have basically got the rest of the country covered. If you set your employment policies to comply with California law, I promise you they are not going to conflict with Idaho or Colorado or like Nebraska, because those states just don't have the same types of worker protections. We understand living on the West Coast that we often have really what may be considered by the rest of the country as quote unquote liberal policies. But those liberal policies protect our workers and give our families a lot more protections in the jobs where they work. So if you can learn how to navigate California, you have basically opened up the rest of the country to you. And I always ask like, all right, you want an employee handbook or you need an offer letter? Where are your employees? And they'll say like, Idaho. Yeah, no worries. Not worried about Idaho. Oregon's easy to navigate. Okay, we're good. Utah is also easy to navigate. California. Okay, now we need to talk. Like let's talk about California. California is really different because, and you should know this, like we said, Oregon is a 40-hour work week, meaning that um, you can work 10 hours and then 4 days a week and then have a day off. And if you work over 40 hours in a 7 day period, it's eligible for time and a half. California is very different. It's an 8-hour work day. So if you have an employee that works 9 hours on a Monday, they are eligible for 1 hour of overtime pay in that 8-hour day. So again, these are just the complexities that we have to navigate, and we can help you do it, but you should know, again, there's some pitfalls, there's some potholes. We want to shine the light on this and help you navigate them. So location really, really matters. Set expectations with your remote workers. Define the work hours, deadlines, deliverables. Be very clear. Again, we are trying to treat people with dignity and respect. Set clear expectations, give them the opportunity to perform and live up to those expectations, and then coach them and manage their performance if they don't. But again, this is just basic human respect and dignity. This is what we expect from you. We're all on the same page. Let's have a conversation. If the goals weren't met, how can we help support you? Make sure that remote workers have access to the tools and the software and all of the resources that they need. If you are using remote monitoring, like if you are using keystroke monitoring software or mouse jiggle monitoring or anything like that, that's fine, but you have to disclose it to your employees. Employees deserve the right to know, and you are required under law to disclose, oh yeah, we use remote monitoring just to make sure that you're working during your work hours. So if you're going to do that, I mean, it doesn't ever feel good to anyone. Nobody likes Big Brother watching them. Employees can find a dozen ways to like circumvent those controls and oversight. So it's not really recommended, but if you do it, you have to disclose. And please be intentional about offering support. Um, we all know that, we've all heard about the loneliness epidemic and this idea of we're not really connected to our communities and the folks around us because we're just so shut up in our homes. So be intentional about connecting with your remote workforce. One of my employees works in Connecticut, and we just have a thing where we just check in with each other every morning, like, hey, it's your coworker stopping by your desk just to waste some time and chit chat. And we'll like share some goofy colleague, like, here's something, right? Like, what'd you do for breakfast this morning? Or you'll never believe what I saw in my commute, right? We don't have those things to share with each other. So we intentionally create those opportunities to connect. And it can be really meaningful to like just have that moment and be like, okay, have a great day. It was nice to see your face. And it's that sense of solidarity working, even though we're apart, we still are in solidarity with one another. Okay, I'm going to pause, ask for questions. That was a lot. Does anyone have any questions or thoughts that they want to share?
Hey, Lindy, this is Chaz.
Hi, Chaz.
How are you?
I'm great. It's nice to see you.
Yeah, I know you can't see me, but I'm driving and now
I
I'm
see your
eating
face.
too, and you
It's
can?
okay. Do your thing, man.
Oh yeah, okay. Hey, you know, I don't have any employees, but I've thought about it and thinking about it in the future. And how, we all know some folks who just generally aren't very healthy people, or they seem to take a lot of time off of work and they're just not available to work. And how do you, is that possible? How do you navigate that as an employer?
Well, hopefully you have good policies that talk about like paid or unpaid sick time. And you you would want to manage that and talk them through it. Like if you offer, 2 weeks of paid sick time a year, and then there's other things that come up that are causing them to be absent from work, you deserve as an employer to have employees who are able to support your business in the way you need. So the way to navigate that is by having one of those human conversations with them. The business really requires you to be available for these things. When you're unexpectedly ill, that really creates a hardship. Should we change around your job duties? Is there something we can do to support you more? And if you need to pivot, then hopefully all of those things are well documented and you're able to show why it's no longer a good fit. But yeah, that's a big concern that folks have is what if I hire somebody that seems really good on paper and then they turn out to be not so great? So another thing you could do is you could have some sort of probationary period or um, some sort of like trial period where you're like, okay, this is meant to be 60 days, 2 months of us working together to see if it's a good fit. These are my expectations during this time. If you're not able to meet those, we will reevaluate and determine if this is a good fit. You have to have folks that support your business because your business is expected to support those people. If our businesses are not, if our businesses and our employees are not creating the revenue to sustain it, that doesn't work for anyone. So we have to be in businesses that are fiscally solvent, and we have to have the right people who can help us with that. So sometimes it can be a difficult conversation to navigate if that happens. Mia had a question. Mia says, is there a template or some sort of example to see employment policy handbook, or most of employers start from scratch? Mia, that's a great question. You can work with an attorney, you can work with an HR consultant. You could probably Google it and find a dozen different examples online that you could look at. What we recommend is either working with an attorney, like we'll give you a set of this is what's sort of standard and recommended. And then there may be other policies that you need. Like if you're an outdoors organization, maybe you need something that's about health and safety. If you are working with commission salespeople, maybe you need something about paying commission. So your employee handbook should be customized to suit your business. Most folks do not start from scratch. It's just no, you don't need to. There's because the non-discrimination, the reasonable accommodation, the religious accommodation, a lot of those things are going to be pretty standard, and you don't want to start from scratch with that. Yeah, Janine said Gusto created a very nice boilerplate handbook. It was compliant with all the states, and that's great. Sometimes that's all you need. You don't need anything fancy or customized. Sometimes the tools that you need will already offer you those supports. All right. Do we have any other questions? Bunny says, can you 100% guarantee that your classification for who you are bringing onto the team is correct? Bunny, the only way you can guarantee that your classification will not be challenged is if you classify somebody as an employee. That is guaranteed to not be challenged. If you classify somebody as a contractor, then we need to go through that sort of weighing the risks and the justifications for it and seeing if we can get more towards independent contractor and less towards employee characteristics. Okay, any other questions? Excellent. Then I will just leave you with this Glow Up Your Biz. If you scan this QR code or visit our website, you can see the other seminars that we have available. We are having one on October 8th that will talk about non-compete agreements and ways that you can protect your business. using other protective covenants and other means, but we have a really good slate of folks to talk to you all. So I hope you join us for some of that. Thank you again for joining me. Thank you for your attention and your participation. And thank you, ORPIB, once again for hosting us. We always love being part of the team. Thanks again. Janine, I'm
Thank you
turning it over
so
to you.
much, Lindy. Well, I'm
Yeah,
gonna just throw all those things right back to you and to all of the folks who joined us today. I appreciate y'all being here. You are not on the Orphan mailing list just because you attended this event, but if you would like to be, it's very easy to subscribe on our website. We'd love to keep in touch.
awesome. Thanks, everyone. Have a great day.
Okay, bye-bye.
Bye,
Thank
all.
you.